Hi, I'm Captain Mike Hankin with the Marshalltown Police Department. With us today on At Your Service will be Assistant Marshall County Attorney Ben Stansberry. Ben will be speaking to us about the Iowa forfeiture law, how it is used by law enforcement, and what they can do with the proceeds.
My name is Ben Stansberry. I'm an Assistant Marshall County Attorney. I primarily handle felony cases, and I work pretty closely with the Drug Task Force. I would say 2/3 to 3/4 of my caseload are drug cases. Otherwise, they're kind of various assorted other things. Most of the bigger counties have a dedicated drug prosecutor. Story County does. Polk County actually has several. So I'd say that's fairly typical. I don't know that Marshall County, I guess I should put it this way, Marshall County isn't unusual in that, given the amount of population we have, that to have a designated drug prosecutor. Civil forfeiture, the simple definition is it's anything that's not criminal forfeiture. But civil forfeiture is basically when the county attorney files a lawsuit against property rather than against a person trying to take their property. So, and that's maybe a little bit confusing, but there's kind of two ways that if somebody commits a crime, the county attorney's office can go about trying to take either the proceeds of that crime or the things that were used to commit it. You can either do a criminal forfeiture where you're essentially prosecuting the person and then take property from the person, or what's called civil forfeiture, where you're actually prosecuting the property itself. The property is the defendant, and it's essentially up to the owner of the property then to come in and try to defend that property from forfeiture by the county attorney's office. Lots of times, in fact most of the time, both happen. There's some advantages to doing it where the civil forfeiture route, just procedurally, it's easier and cleaner in order to essentially end up with title in the case of a car or houses, that sort of thing, to do it the civil forfeiture route. There's also some advantages in the criminal forfeiture, the non-civil forfeiture route. A person's Fifth Amendment rights still apply. So if the criminal proceedings are still going on, they're obviously not going to want to deal with the forfeiture side of that, because they might have to give testimony or make admissions about the property that would hurt them in the criminal case. In the civil forfeiture route allows the county attorney to essentially have both proceedings going at the same time. And there's a different standard of proof in civil forfeiture. And criminal law, most people know this, you're guilty until you're proven, or you're innocent until proven guilty beyond a reasonable doubt. In civil forfeiture, it's a different standard. It's called the preponderance of the evidence, which basically means, 50-50 more likely plus one. So it's whoever has the better evidence wins in a civil preponderance of the evidence standard rather than the beyond a reasonable doubt. It's important to note that in a criminal proceeding, being found not guilty is not the same as being found innocent. And it kind of goes back to that higher burden of proof beyond a reasonable doubt. It happens fairly regularly that a jury may come back with a not guilty verdict. They may think yeah, the person probably did it. Given the evidence, we think the person probably did it, but there's still a doubt that's reasonable that would explain or why they might not have. Whereas in a forfeiture proceeding, again, the standard of proof is lower. It's also, a lot of times the issues in forfeiture proceedings are not the same as in criminal proceedings. So, for example, we'll use a car. A car could be subject to forfeiture if a person drove it to where the crime was committed, drove it back from where the crime was committed. In the case of a drug crime, I deal with this all the time, if the drugs were transported in that car, any of those three circumstances could make that car subject to forfeiture. Whether the person was or wasn't driving the car is usually more of a cut and dried issue and isn't something that normally would lead to a not guilty or a guilty verdict in a criminal case. So that's kind of a long answer to your question that, the issues in a forfeiture proceeding aren't always the same, either factual or legal issues that would lead to a not guilty verdict in a criminal proceeding.
But you don't have to prove that the person was guilty, and you don't have to prove that the car was used.
We do. That's ultimately what makes it subject to forfeiture, is that it was, the legal term is an instrumentality of the offense. So you have to prove that that particular item was used, and you have to prove that a crime was committed. But again, it's by that lower preponderance of the evidence standard, more likely than not that a crime occurred.
So what point in a investigation is the forfeiture initiated?
There's kind of two ways that you can do that. You can do it right away, so that essentially the forfeiture and the criminal case run at the same time. The other way, forfeiture actually starts when law enforcement designates the property as having been seized for forfeiture. So property can be seized as evidence and held by law enforcement while the case is proceeding, and not designated as seized for forfeiture until the criminal case is over with. So it's sort of up to law enforcement, to the police, the sheriff's office, our office, to designate property specifically seized for forfeiture as opposed to seized as evidence or being held for some other permissible purpose. During a criminal investigation, depending on the crime, lots of things can be seized as evidence that either aren't worth anything, or at the time they're seized, we just simply don't know whether, how they fit in. They have evidentiary value, but we don't know if they belong to the suspect, if they belong to the victim. There's all sorts of property that's seized that either we don't want to deal with or we may not want to forfeit. So as the case gets sorted out, we can kind of sort through and figure out what are those things that should or are worth being forfeited and what aren't. So lots of times the decision as to whether or not we're going to go about forfeiture proceedings aren't made until after the case is sort of wrapping up, and then we'll designate it for forfeiture, and then that actually triggers some deadlines as to when you basically, after you designate property seized for forfeiture, that puts a deadline on me of 90 days to get the formal application on file to actually start that civil case.
Okay.
So property doesn't normally defend itself. Essentially, if the defendant, if the owner, the interest holder knows that there really isn't a defense, they don't have to do anything. And after 30 days of not filing what's called an answer to that application, that petition I just talked about, they're in default, and I can apply to the judge and just have a forfeiture ordered saying nobody's going to defend this. It now belongs to the state. If they do want to defend it, they have to file what's called an answer, and have to kind of loosely lay out why it should not be subject to forfeiture, and then the court will schedule a hearing. That normally happens with either cars or cash. Those are kind of mainly because those are two things people care about the most, I think. They're usually worth the most. But the way some common defenses for cash are, it wasn't proceeds from my drug dealing, it was wages I earned from my legitimate job. That's kind of the most common. The other thing, like in the instance of a car, it would be there were never drugs in that car. A lot of times it will be, a car could be registered in somebody else's name rather than the actual defendant from the criminal case. So the person that the name on the actual registration may come forward and say, that's my car, it's registered in my name, this person was driving it but used it without my permission, or some sort of, essentially, I shouldn't be held accountable, or the car shouldn't be held accountable for the illegal actions of this person because of, it was their wrongdoing, not mine. What the state has to prove is that a crime occurred and that the property was connected in some way, and it's set out in Iowa code the different ways property is subject to forfeiture. The two most common are either their proceeds or that they were actually used, the property was used in the commission of a crime. The state doesn't have to file a criminal case against somebody to start forfeiture proceedings. And it goes back to the burden of proof. As long as the state can prove by that preponderance of the evidence standard that a crime occurred, then the property is subject to forfeiture.
So if I'm driving down the road with a pile of cash in my seat, you can't take that away from me.
Well, our office has not done that. There are, the stories that have made the papers and the news from across the country are instances where that actually has happened, and there's nothing in the code that would prevent that from happening. As a policy issue, our county attorney, Jennifer Miller, has decided not to do that in the past. I can't say that it would never happen here, but it hasn't happened here.
But there would be no crime.
There's two ways that can happen. Again, I've never personally done it, but professionally, I know of a couple ways that can happen. One is and it normally is large quantities of cash. You have $30,000 in the car and no good or ready explanation as to how that cash got there, where it was coming from, where it was going. Some cases, the driver of the vehicle even says, that's not my cash, I don't know anything about it. So you start a forfeiture proceeding on the cash, you wait the 30 days and nobody comes to defend it, and it automatically becomes the property of the state. Usually the presumption is it is some sort of proceeds from illegal activity, and nobody wants to come and admit that or put themselves on the hook for that. Sort of lost my place. The other way that could come up is if, for whatever reason, the determination was made we think that a crime probably occurred, that, you know, it's more, again, it's more likely than not that a crime occurred, but for whatever reason, we don't think that there would be that proof beyond a reasonable doubt. The decision could be made, well, we'll proceed with forfeitures, but we won't file a criminal charge. Again, playing with that, the higher versus lower burden. Like I said, to my knowledge, I have never personally done it, and to my knowledge, that has never been done here in Marshall County, where we have done a forfeiture without also having a criminal charge arising out of that same incident or investigation.
I can't believe somebody hasn't challenged those policies.
They have, and the Register, I think, had a several day kind of expose about that, where the example that I remember from that story was, I believe there was a young man from Chicago that was traveling through the state of Iowa on the interstate, was stopped, found, I think it was around $30,000 in cash, somewhere around there. And his explanation was, I essentially sold everything I had, picked up everything I had in Chicago. I was on my way moving out to California, where I was going to essentially start a new life, and the police, law enforcement started forfeiture proceedings on the cash, not believing his story, thinking that he was a drug courier of some sort, and they went and litigated that. And I don't remember off the top of my head how that turned out or how it has turned out. But so people have fought it. You should fight it. I mean, if there is a legitimate defense, the process is in place for people to present that. I've had forfeiture cases where, the person has pled guilty to the drug offense. That they've either pled or been found guilty of being a drug dealer, but still fought the forfeiture of the $8,000 in cash that was seized during the search warrant, saying, yes, I was a drug dealer, but I was also working here and I earned this much money, so I should get that much out of the cash that was seized. I should get some of that, some or all of that back.
Did he get some of it back?
I have had cases where, yes, people get some or all of the money back. It's usually a portion. It's sort of complicated by the fact that case law that has grown up around this has established that once you take illegal money and mix it in with legitimate money, it dirties up all of the money. Mm-hmm. So there's
kind
some.
of like the Planned Parenthood thing.
I don't know.
Because
Oh, I see what you're
our
saying.
state money wasn't used for.
Yeah, I see what you're saying. Yes, that basically the dirty money taints all of it is sort of how it's come up. But
Well, you kind of have to believe that even if a drug dealer had a legitimate job, some of that money's buying drugs.
right, yeah, and depending on how the hearing goes, it can sometimes get as technical as that, as figuring out, well, you had this much in rent, this much in utilities, this much, that absent your illegal activity, you didn't have enough legitimate income to cover your expenses. So, and it can get that complicated.
So
Forfeiture money is important to law enforcement efforts. I should first say, none of that money can be used to pay salaries. So nobody's job depends on generating forfeiture money, and I think that's important. There's no hand-to-mouth incentive,
no quota.
right, on doing forfeitures. Having said that, what it is used for commonly there's three things. One, law enforcement can make direct use of the things they seize. So cars, sometimes those are directly converted into either, undercover cars or used by, the seizing agency directly. And property, cars are often also auctioned off, and the proceeds, some of it goes to the state, some of it goes to most of it goes to the law enforcement agency, and a little bit comes to the county attorney's office. Can be used to pay for training, so going to classes, new skills as far as things that we normally wouldn't be able to do. If there's classes out that are offered by the FBI or DEA that are offered, for like cell phone analysis, those sorts of things those classes can be pretty expensive, and might not always be available if we didn't have forfeiture money to help defray some or all those costs. Forfeiture money can also be used to buy things, actual items that are used, and it can be as unglamorous as plastic baggies that you need to bag up evidence, to things like cameras, microphones, and GPS trackers and things like that. Those are some kind of big ticket items. I think most people might be surprised at the cost of like a GPS tracker. Is it can run up to $3,000-$4,000, and that's often outside the budget of something that a law enforcement agency could buy, absent the money coming in from forfeitures. Is there an incentive to do forfeitures? Yes, but I think there actually probably should be. I mean, in some respects, if drug dealing is being done for financial gain, then the thing that's going to hurt those people the most in some respects is taking that financial gain away. And you do that by taking their toys, taking their cash, and removing that incentive from them to continue dealing drugs in our community.
If they are drug dealers.
If they are drug dealers. Yes, right, exactly. Cellbrite is the brand name. It's a kind of computer that is used to download the contents of cell phones.
Oh, really?
And
Never heard of that.
yeah, and they're expensive. And the way a lot of these companies work is you have the upfront equipment cost, but then you have a yearly fee, in some respects, almost as much as the initial cost to renew the license and to do the software updating. So, your $5,000 upfront cost is, bad enough, but then you have a $2,500 yearly update fee, and then you have another, $2,500 training cost, and that's kind of how they end up with their money. But my experience with dash cams is pretty much all just the police side of things.
What do you think of that idea of people using this as evidence?
I'm fine with that.
I mean, is it admissible for somebody
Yes.
to bring in?
Yeah.
Okay.
Yeah, it would be admissible. I mean, there's problems we run into with dash cams in that they're only as good as what they're pointed at. Mm-hmm. So, at least with dashboard mounted things, I mean, your car has to be pointed at what you want to be filming, otherwise it's not going to do a whole lot of good.
Right.
And, video evidence shows what it shows, but it doesn't always show everything. You don't, depending on the angle, you can't necessarily see, in a lot of cases, the fighting issue is often hidden from view, and so just because you see it on video doesn't mean that tells the whole story. But no, certainly the public is more than welcome to video and use that as evidence.